I think I think it looks like the participants have stopped entering the room so quickly, so we are ready to get moving. Again, thank you for joining us today for HR Basics for the non-HR professional. Before we get started, a little bit of housekeeping. As always, our webinars are being recorded, and we will do some cleanup and editing on the back end, and all participants will receive an email in a couple of days with the link to the recording of the webinar. And as we do every webinar, we use the Q&A button for questions that you may have. So please do not use the chat. If you have a question, please submit it through Q&A. We do have time dedicated at the end of today's webinar to answering whatever questions you may have. And we know that HR tends to get a lot of questions. So if we can't cover everything, our presenter Brittany has graciously offered to take questions from people offline and be a resource after the webinar if we do not have enough time during the webinar. So please feel free to use the Q&A and we'll get right into things. I'm Peter Benson with Park Bank. I lead our treasury management and our community engagement team. And I'm very, very happy to introduce to everybody Brittany Hanson. Brittany, as well as being a fabulous Park Bank employee, has developed a broad range of skills and experiences in over 15 years of working in the HR space. As Park Bank's AVP of HR operations, Brittany focuses on training and development, performance management, and employee relations. With the help of her team, she also helps to support our payroll function, benefits, recruitment strategies, and internal communication. As you can see, Brittany, she's a key player on the Park Bank team, and we are all thrilled to have her here to share her expertise with us in the HR world today. So Brittany, thank you for taking time, and I will let you take it away.
Thanks very much, Pete. Appreciate it. Well, one thing that you did not hear Pete say is that I am an attorney, which I am not. So before we dive into HR basics, just a little disclaimer, the content is not legal advice. This is general information from my experience, training, and research over the years. Think of this session as kind of an HR basics crash course. My goal is about 2 minutes per slide. Hopefully we can get through everything that I want to cover today. But like Pete said, happy to take questions certainly at the end of this session as well as offline. And specifically, if you have questions about your own organization and unique situations, I'm happy to take some questions about that as well. So high level first, let's talk about why HR is important, right? So whether you have a small business, a large business, a nonprofit, a for-profit, or anything in between, all businesses need people to do their work, right? So everyone's talking about AI right now, but at the end of the day, your people are getting your work done. And maybe you only have one employee, maybe you have 2 employees. But having a fundamental knowledge of HR basics is really important to make sure that those people can continue to carry out your mission and do the work that you need them to do. So what does HR do in an organization? HR ensures that an organization achieves success through people. So we focus on a lot. High level, we're focusing on policies and systems, laws and regulations, and culture, engagement, and really maximizing that employee performance. We're going to focus a lot today on specifically those laws and regulations. There's a lot of them. They can sometimes be a bit daunting, especially for small businesses or nonprofits that have folks that are wearing a lot of hats. So moving right in to talking about laws and regulations, there are federal employment laws, local employment laws, state employment laws, and sometimes they're different. Sometimes they're the same, but sometimes they're different. So what employers need to do is when a federal law and a state law differs, apply the most generous law in favor of the employee. So there are some examples of this. The Family Medical Leave Act, or FMLA, is a great example of that. I'm not going to talk about that a ton today for this webinar. The FMLA applies to organizations that have 50 or more employees. However, there are federal FMLA regulations, and then there are Wisconsin state FMLA laws, and they differ. So if you know an HR person who's administering FMLA in Wisconsin, give them a hug because it can be complicated having to look at both laws. Another example is minimum wage. So there is a federal minimum wage. The federal minimum wage is currently $7.25 an hour. However, some states in the United States have chosen to have state minimum wages that are higher. So California is an example, Washington, D.C., Washington State. So employers in those states have to pay that higher minimum wage because that is more generous in favor of the employee. Here in Wisconsin, our state minimum wage is the same as the federal minimum wage. So it's $7.25. Next topic, high level, talking about employee files. So if you have, again, even just one employee at your organization, you should have a file for every employee. Employees have a right to view those files and have copies, and that includes former employees also. So what should be in an employee file, right? There's a lot of different types of paperwork and things that we develop and accumulate over time as somebody is on staff. So what should be in the file? Things that are objective, undisputable facts. So some items listed here: offer information, benefit information, performance reviews, etc. Right? Facts, these things are undisputable. What you want to not put in an employee file, and there's a few things here, medical information. So if an employer has any information from somebody missing work because of a medical situation, FMLA, etc., that shouldn't be in the employee file. That should be kept separate. And that information and data is subject to HIPAA, and that is something that HIPAA dictates that it needs to be in a separate file. I-9s, which are a required document for everybody in the United States to have in order to be working. Those have personally identifiable information in them, information about citizenship status. And so those should not be in an employee file. Those should be separate. Similar concept for background checks. So if your company does background checks, those should be kept in a separate file. And typically you want to have those in if you have physical files, a separate physical file, maybe a separate drawer or a separate file cabinet. And if you have digital employee files, which is great, you still want to keep these things separate. So you just have them in a separate folder. Another thing that you want to avoid putting in an employee file are anything that might be subjective, bias, or opinion related. So some examples could be interview notes or manager notes from coaching. So sure, there could be some objective facts in those notes, and often there are opinions or maybe some bias in there. And it's up to you, where and how you keep these things. However, you wouldn't want to keep them in an official employee file. Whatever you're putting in an employee file, ask yourself, is this something that I'd be okay with this person having if they requested a copy of this? So that's employee files, very high level. Employment law posters. This is another really important regulation. Hopefully you've seen some of these in your workplace or at other places of employment. It is a requirement for employers to post employment law posters or labor law posters. And again, these posters cover many of the state and federal laws that require you to communicate these regulations via posting. You have to post them in a place that is accessible for all employees. So think about a break room, think about a common area that people are often in. That's where they should be posted. And if you have remote workers, you should also have them posted on an intranet or another place that's commonly used. So intranet is a common place. If you have remote employees, you want to send links annually when there's poster content updated, and you do want to keep them current. So this link here is a great resource. The Department of Labor has a lot of information on workplace employment law posters, and you can actually get these for free on the Department of Labor website. You can also pay a service. There's organizations that provide a service where they will send you labor law posters. If there are any employment law updates, they will keep track of that. They will send you new posters when there are required changes that have been made. So it's really up to you and your organization's budget and other strategies if you want to have utilize the Department of Labor resources to get the free posters. You just have to make sure that you're keeping track of when the law changes or when new things need to be posted. If you, and some organizations that provide that service, SHRM, the Society for Human Resource Management, JJ Keller, they are local in Wisconsin, but they offer that service all over, are some organizations that can offer employment law posters. If an organization doesn't post an employment law poster, or they have an outdated employment law poster, or they don't post it in the right spot, there can be fines. The Department of Labor is the governing body that oversees employment law and specifically this regulation. So if an organization is audited by the Department of Labor and it's found that these, again, aren't posted in the wrong spot or outdated, there could be fines anywhere from a few $100s to up to $20,000. I've seen once as high as $23,000 for a max violation for not displaying one labor law poster. And there are several different laws that have to be displayed via posting. So really important to keep up to date on this. So now, like I said, this is an HR basics crash course. Next, we're going to shift gears and talk about exempt versus non-exempt. So you may be familiar with these terms either for yourself or for folks at your organization. This classification generally refers to the payment of overtime. So very high level, if a job is non-exempt, that typically means that that job is not exempt from overtime. Anyone in that job is not exempt from receiving overtime pay if they work more than 40 hours. So they are owed overtime pay. Typically, if a job is exempt, that means that individuals working in that job are exempt from overtime, meaning they do not need to be paid overtime if they work more than 40 hours. You'll notice I'm saying typically because there are some unique situations where those different things I just shared might actually not apply. We're not going to dive into those unique situations. Again, that's something if you have a unique situation at your organization, happy to answer a question about that. Also notice that I have said if the job is non-exempt or exempt, because we're talking about jobs. We're not talking about people, we're talking about jobs. So you might have two people in the same job. And if one person says, well, I want to be salary or I want to be exempt, and the other person says, I want to be non-exempt, we can't differentiate that between people. Non-exempt and exempt is applying to the job they are working. Technically, all jobs are considered non-exempt unless they meet an exemption. And we'll talk about what those exemptions are. So, and something to keep in mind, 80% of the job duties have to meet the exemption. So to be exempt, a very important factor is the minimum salary. So individuals have to have a minimum salary of $43,888 to be exempt, an annual salary. This increased in actually July of this year pretty significantly from $35,568 per year or 35,000, excuse me, 35,000. That's going to go up again. So these are new regulations where the Department of Labor increased the minimum salary. So in January 1 of 2025, that minimum salary to be considered exempt is going to go up pretty significantly again to about 58,000 per year. So what does that mean? Right now, if anyone at your organization is making $43,887 or less, they cannot be exempt. They are non-exempt and they are owed overtime. And again, that's going to go up at the end of the year. Just a few additional things here. You can only use non-discretionary bonuses and incentives to come up with that minimum salary, right? So we're thinking about their base salary and then potentially non-discretionary bonuses and incentives. And that can only account for up to 10% of that standard salary level. And then individuals must perform exempt duties in order to be considered, or the job, individuals in the job must be performing exempt duties in order for the job to be considered exempt. And then there's some specific exceptions. So these listed here, folks that are in these types of roles, regardless of what their salary is, they are non-exempt and they are eligible for overtime. So what are the exemptions, the exempt duty categories? I'm not going to go through all of these in super detail. We could certainly spend a lot of time talking about this, but the exempt duty categories are executive. So executive level positions, administrative positions, professional positions, computer related positions. So think IT, and then outside sales. So if the primary duties of a position fall under these categories, then they should be considered exempt. There are a lot of resources out there. The Department of Labor has those resources, and this one in specific. So fact sheet 17A will go into more detail on all of those exempt categories that we were talking about. And again, like I had shared before, if the primary duties of a position fall under these categories, the Department of Labor interprets the word primary or primarily as more than 50% of their work time is spent on those exempt duties that fall under those exempt categories. So great resource here if this is something that you want to get more familiar with. Okay. So we're going to continue talking about pay and overtime, right? So speaking of overtime, just some facts for you. When is overtime earned? So when someone works more than 40 hours. Who can receive overtime pay? Again, non-exempt employees, not contractors. So we're going to talk about contractors in a moment, but the only people that can receive overtime pay are non-exempt employees. What is the rate of overtime? Time and 1/2. How is work paid on Saturday or Sunday? That depends on your work week. So as an organization, you should indicate what is your work week and then stick to it. And folks that are working more than 40 hours in a work week are then eligible for overtime. So most of us have a Monday through Friday work week, right? So if somebody works more than 40, or they work, 40 hours Monday through Friday, and then they come in on Saturday and they work 5 hours, they are owed overtime for those hours on Saturday. Some companies might have a work week that's Tuesday through Saturday. So if somebody works 32 hours Monday through Friday, or Tuesday through Friday, excuse me, and then they come in on Saturday and they work another 8 hours, they're not eligible for overtime just because it's a Saturday. That company's work week is Tuesday through Saturday. They work their 40 hours, nothing more than that. They receive their normal pay. And then a question that folks sometimes ask, can overtime be banked to use as PTO at a later date? Not for private employers. Technically, based on employment laws. That's not something that private employers can do. Some public employees, so city, state government employees, have a system where, let's say they work 40 hours and then they do come in on a Saturday or whatever day that they're over 40 and they work another 8 hours, they get to bank that time at time and a half as time off. Private employers cannot do that. So anyone that works even 30 minutes, 15 minutes, anything over 40 hours, they are owed that overtime pay. So again, there's a lot more than we could touch on here when we're talking about exempt versus non-exempt, but hopefully this has given you a basic overview, basic understanding of what that looks like. We mentioned contractors before, so talking a little bit about independent contractors versus employees. So what is the difference and why do we care? The IRS cares about it. There are some tax implications as well as some benefit implications, and also some implications related to the Fair Labor Standards Act, which is the oldest or one of the oldest employment laws in the United States. So the Department of Labor pays pretty close attention to this. So if you employ contractors or you have both employees and contractors, this is an important concept for you to have understanding and awareness of. If an organization misclassifies somebody, they could owe there could be pretty significant financial implications. Specifically, they could owe back pay, benefits, taxes, etc. There's a quote that I found that I really like when I talk about this because I think it really highlights the importance of this. So I'm just going to read it. Misclassifying workers as independent contractors adversely affects employees because the employer's share of taxes is not paid and the employee's share is not withheld. If a business misclassified an employee, the business can be held liable for employment taxes for that worker. Generally, an employer must withhold and pay income taxes, Social Security, and Medicare taxes, as well as unemployment taxes. So let's say you have somebody that's been working for you as an independent contractor for a few years, and it turns out they were misclassified and they should have been an employee. There have not been any taxes withheld or paid for the entirety of that person's time with you. You might owe, or an organization might owe, back pay for all of those taxes, right, to the government. We don't offer benefits to independent contractors. We do offer benefits to employees. So if somebody was classified as an independent contractor incorrectly, an organization might owe that person money that equals, whatever benefits they would have received in that time if they had been classified as an employee. So there are 3 components that you look at when you are thinking about classifying somebody as an independent contractor versus an employee: financial control, behavioral control, and then the relationship of the parties. So when we're talking about financial control, right, does the worker have a profit or a loss? Does the worker have unreimbursed business expenses? When you're talking about an employee, the answer is no. They're paid their pay regardless of what they're doing, and they shouldn't have any unreimbursed business expenses. Independent contractors do. So an independent contractor, they are purchasing their own supplies. They're utilizing their own technology. Maybe they have a physical office they work out of. So if they have a really good year, they might have a profit, right? So they're paying for all of those things. Anything on top of that, that person might have a profit. If they don't have a lot of clients that year, they might have a loss. So that's a big difference, as well as, again, those unreimbursed business expenses. When we're talking about behavioral control, what type of direction does the worker have from the organization? So employees have all of the direction from the organization regarding what they should be doing, what the purpose of their job is, what are the expected outcomes, etc. With independent contractors, they certainly might have some direction from the organization. You might hire an independent contractor to do some marketing work or some video work or consulting work, and you're going to share what you're looking for. However, they are really going to drive how they're going to provide that, what they're going to provide, the resources that they're going to use, the knowledge that they bring to the table. So they are really driving that. And the organization isn't necessarily providing 100% direction. If they have more than one client, so independent contractors might have more than one client, right? Pete shared, I'm an employee of Park Bank. If I was an independent contractor, maybe I would be providing consulting to Park Bank, but then several other organizations. That's not the case. I only work for Park Bank. And then if they operate under a different business name, so same idea. If I was an independent contractor, maybe my company name would be Brittany Hanson HR Consulting, but that's not the case. I work at Park Bank. I'm an employee of Park Bank. I don't have my own separate business name. And then relationship of the parties. So a written contract typically exists with independent contractor relationships versus employees. We're an at-will state in Wisconsin, which we'll talk about later. So we don't have contracts typically for employment relationships, but when you hire an independent contractor, you do. And then you're also looking at the permanency of the relationship. So theoretically, as an employee, that you are employed by your organization indefinitely until one of you decide to end that relationship. Contractor, there's typically parameters put in place. You might say, we're going to hire this contractor for 6 months to do some consulting work, or for a year to help us implement a new system. So there's a defined amount of time that that person is working with you. So if this is important to you, this IRS resource here, the Worker Classification 101, is very helpful to understand and dive into a little more detail on independent contractor versus employee. So moving on, let's talk about meals and breaks. So interestingly, most people think differently, but there technically is no federal law governing meals and breaks. So most of us in our, career and working life have been at organizations where you take a break. That's a best practice. Certainly we all should have breaks, right? To be able to keep up with what we're doing all day, but technically there's no federal law dictating that. However, there are some Wisconsin laws that organizations and employers have to follow. So we talked before about differences in federal and state laws. If there is a Wisconsin law that's more generous to the employee, we in Wisconsin have to follow that. So for minors in particular, there are some pretty specific meal and break laws that exist. So this resource here, if you employ minors, youthrules.gov has really great explanations and resources regarding that. For anybody, regardless of whether they're a minor or not, there are some regulations in Wisconsin that dictate how you pay people when it comes to meals and breaks. So you don't need to pay somebody for a meal or break, unless the break is less than 30 minutes, or they are not a complete relief of duties. So if a break is less than 30 minutes, I think I worded that right. You do need to pay somebody, right? So if someone's just stepping away and taking a 15-minute break, they should still be paid. If it's longer, 45, 60 minutes, technically they can clock out if we're talking about non-exempt folks, hourly folks, and you don't have to pay them. The other stipulation here is that you don't need to pay someone for meals and breaks unless it is not a complete relief from their duties. And this is really important. And there have been some cases and there's case studies out there about this. So if someone goes on their break, but the manager says, hey, yep, go on your break. However, can you just keep an eye on the lobby? And if any customers come in, can you go talk to them? That's not a complete relief from duties. That person should be paid. Or, hey, yep, go on your break. But if you could just monitor the phone, if the phone rings, answer it. You can send it over to me, but I just need you to monitor for phone calls. That's technically not a complete relief from duties, and that person should be paid. So complete relief from duties is key if someone is having an unpaid break or meal time, as well as it being longer than 30 minutes. Okay. We're moving along. So Wisconsin also has laws around travel pay and training pay. So again, in this situation, Wisconsin law is more generous than the federal law. So there are some federal laws in place for travel and training pay. However, teeny tiny at the bottom there, you can see the administrative code that goes into great detail on requirements for employers when it comes to travel and training pay. So when we're talking about travel pay, all time traveled for work-related purposes during the workday have to be paid. You want to subtract out normal commute time, so you don't have to pay somebody for normal commute time typically. And again, pay anyone for time spent traveling for the employer's benefit. So if somebody is driving to a client meeting, somebody is going to an offsite meeting, someone's running to pick up lunch, like all of that should be, that person should be being paid for that time, that travel. And then paying for training. So you want to assume that any training that you're having any of your employees do needs to be paid. So they should be paid while they're in the training, unless all of these four requirements here are met. So if the attendance is outside of the employer's regular working hours, and it's voluntary, and it's not directly related to their job, and they're not doing any productive work during that training, then you don't have to pay them. But a situation where all four of those things are met is pretty rare. So in the workplace anyway, so you likely are going to be paying people for their training. So if the training is within their normal workday, it's not voluntary, so you've mandated them to go. It is directly related to their job, and they're going to be performing some sort of productive work during their attendance at the training. You do need to pay them for training. There's a handful of more components to talk about here when it comes to travel and training pay, and there's some specific things that come up, like what if somebody is on call and they're, called to an emergency? Should they be paid for that drive from their home, right? So that administrative code provides some more detail for some of those unique situations, and I'd be happy to answer any questions about that as well. So next, we're going to talk about a pretty big topic for employers, a pretty big topic for the workplace, and that's harassment and discrimination. So we could talk for this whole hour about the importance of understanding employment law as it relates to harassment and discrimination. We can talk all day about this. There are trainings that are the full hour or the full day around this. I have 3 slides talking about this, so very high level here, and really critical for employers and leaders to have an awareness of this topic. So in the workplace, organizations cannot discriminate against any protected classes for any reason. So when we're talking about hiring, terminations, promotions, training, organizations cannot discriminate against protected classes, right? What you see here are a list of all of the different employment laws that exist that provide protection to employees from harassment and discrimination in the workplace. The Equal Employment Opportunity Commission, or the EEOC, is the governing body that governs and oversees employment law as it relates to harassment and discrimination. So there is an EEOC website that has loads of information about this, but that is the organization that if there is ever a harassment or discrimination complaint, it would go to the EEOC and they would potentially investigate that complaint. So what are the protected classes? So we said you cannot discriminate against any protected classes for any reason. Protected classes include race, color, religion, sex, including pregnancy, sexual orientation, gender identity, national origin, disability, or genetic information. So talking a little bit more specifically about harassment, right? So when it comes to harassment in the workplace, what does that mean? So first, it means unwelcome conduct, right? Based on someone um, being a part of one of those protected classes that we talked about. What unwelcome based on whose perception, right? The targeted individual. So if an individual in the workplace is the subject or the target of harassment, if it's unwelcome according to them and how they feel, then that's enough to describe it as harassment. Also, if unwelcome conduct is being observed by a bystander, that is also harassment. So if there is an individual who is the target of harassment by another individual in the workplace, if there is a bystander, so somebody that has a desk near that person, or maybe they're walking by and they hear or see harassment taking place, that bystander can also say that they were subject to harassment in the workplace and they could potentially file a harassment claim with the EEOC. Harassment becomes unlawful when it becomes a condition of employment. So in other words, somebody has to put up with XYZ unwelcome conduct in order to stay employed, or the conduct is so severe or pervasive enough to create an environment that a reasonable person would consider it hostile or abusive. So when we say reasonable person, let's talk about that first. So who determines what that means? What is the reasonable person standard? When a harassment or a discrimination case, or in this situation, a harassment case goes to the courts, it is the courts that are determining what the reasonable person standard is. So judges, administrative judges, juries, and probably not surprisingly, they tend to lean towards the employee and the employee's situation, the employee's experience versus the employer. When we're talking about unlawful too, technically, right, these employment laws protect folks that are in a protected class, right? So technically, if we're talking about employment law, if there is somebody who is being subject to harassment and they don't belong to any of these protected classes, there may not be a legal case for that. However, it is a very recommended best practice of every organization to just have zero tolerance policies for harassment, bullying, anything like that. So regardless of whether someone is a part of a protected class, it is a best practice that organizations, to prevent any type of harassment or discrimination, to have zero tolerance policies for that. And then there are anti-discrimination laws that prohibit retaliation as well. So if somebody, files a harassment or discrimination claim, the organization or the person that was the harasser can't retaliate against that person. That is unlawful. Something to remember, it's a quote that I always, when I'm talking about these things with employers or doing presentations like this, thinking about discrimination and harassment. Discrimination is not always harassment. However, harassment is always discrimination. So harassment is essentially a form of discrimination in the workplace. So what can employers do, right? How do you prevent harassment and discrimination? Provide training. Technically, there's no law saying that a company has to provide training. However, best practice, right? Provide training to your leaders, to your associates. Create policies. So create policies that are clear and stick to them. And then build a strong culture. So you want to build a strong culture where those behavioral norms are way above the line, and just make that the norm. Make that the only acceptable behavior in your organization. And that's a great way to prevent any issues with harassment or discrimination. So we're doing great on time. We're going to talk a little bit about some components of the employee life cycle next, and including interviewing. So when we're talking about interviewing, right, if you are recruiting and trying to fill a position at your organization, there are some employment law things to think about, as well as just some best practices. So technically, protected classes and anti-discrimination employment laws apply to the interview process. So even before somebody is employed by your organization, if they feel in any way that they were discriminated against or harassed in the interview process, they have just as much of legal standing to file a complaint that one of your employees has. So it's really critical that leaders have an understanding of employment law and best practices for recruiting and hiring. So some of those best practices are listed here. You want to ask every interviewee the same question. Probing question, or the same questions, excuse me, meaning you don't want to have candidate A and they get asked these questions, but then candidate B, it gets asked different questions, because that can open up potentially some risk for if one of those people isn't hired, they feel like they were discriminated against, and it turns out they weren't asked the same questions. So ask every interview the same questions. A question that I've gotten a lot from managers is about probing questions, and that's fine. So you're still asking all of your candidates the same questions, and maybe candidate A gave you all of the information that you need, and you know what you need to know to make your decision. Maybe candidate B, when they answered that question, there's a little more information that would help you. So you can say, tell me more, or can you elaborate? That's completely fine. Another thing that's okay too is to probe into claims made on a resume. So let's say someone on a resume, they're interviewing for a sales position and they say that they sold, 5 million last year. Let's, ask them about that, have them talk a little bit about that to understand how they were so successful and make sure that that's a legitimate claim. And then going back to the questions that you're asking, you want to make sure that they're job related and consistent with business necessity. Really important here. I know we all have maybe been asked at some point in our life or heard about the question, like, if you could be an animal, what animal would you be? Or what if you could be a candy bar, what candy bar would you be? Those are fun. However, not related to the job, not related to business necessity, could open you up to risk if somebody wasn't hired for a job and then they say, well, they asked me what kind of animal I wanted to be, and that had nothing to do with the job. So something to keep in mind. Maybe save those questions for like a team builder at your, on a team meeting or something like that, and not in interviews. So these questions here are some, potential interview questions. However, only one of these questions is a legally okay question to ask. So I'll give you a few seconds to take a look at this list of questions and maybe decide what you think is an okay question to ask in an interview. So the first question is not an okay question to ask in an interview. Are you married? Nothing to do with the job, nothing to do with the business in any way. Do you own a car? So instead, the way you want to word this is, do you have reliable transportation? Because someone might not have a car, but they could very easily get to your organization on the bus or bike or whatever works for them. Can you work weekends? That is the question that's okay to ask. And because business necessity, you might need people to work on the weekends, right? Where were you born? Not at all related to the job, not appropriate to ask. Do you have a disability that would affect your ability to do this job? We're not going to talk about the ADA today, the Americans with Disabilities Act. That is a really important law for organizations to be aware of. You want to ask about disability status and any potential accommodations that somebody would need after a conditional job offer is made. And then, do you have dependable daycare? So instead, ask, here is the schedule for this job. Will this schedule work for you? So important to keep in mind, thinking about how you're wording the questions that you're asking, so you're minimizing the risk that you might be subject to when you're working through the interview process. So interviewing, right? We're interviewing somebody. Let's say we hired somebody, we're excited, we have a new employee. There are some mandated benefits that exist that every employer, regardless of their size or type of industry or anything, has to provide to the individual. And there's just some certain things in the new employee onboarding process that every organization has to do. So we talked about I-9s a bit before. So I-9s are something that it's a form that every, whenever you're hiring somebody in the United States, you have to have them fill out the I-9. And the I-9 is just confirming their citizenship or their ability to work in the United States. So their citizenship status, and then their identity. So two things that are required in order to have somebody working for you. And then new hire reporting. So technically, organizations should be reporting new hires and into their organization to the government for purposes of like if there is a garnishment for wages, for child support, or anything like that. That's what the purpose that new hire reporting serves. If you have a payroll system or like an HR system, an HRIS, those systems are typically doing that for you. However, if you don't, there are really clear guidelines and outlines out there to help you with that new hire reporting. Social Security and Medicare required as well. So every employer has to pay Social Security taxes, right, at the same rate that their employees are paying them. You take it out of their wages and you send it to the government, right? So the current rate, and this is, I believe, still the current rate. These numbers were put together a few months ago. 7.65% of the base wage. So 6.2% of that is for Social Security, and 1.5% of that is for hospital insurance, otherwise known as Medicare. There is a max for Social Security. So if that's something that you're interested in learning about, you can look online. You have to keep paying Medicare regardless. There's no max on that. And then unemployment insurance, workers' compensation insurance. So those are things that our employers need to have as well. The state of Wisconsin technically doesn't write workers' compensation insurance. So as an employer, the organization has to find, an agency, right, that will provide them with workers' compensation insurance. There are over 300 insurance companies or agencies in Wisconsin that offer that. So you simply have to seek that out. We mentioned FMLA before. Again, not going to talk about FMLA today. That is the Family Medical Leave Act that provides job protection for individuals that have to miss work due to a personal or family health or medical related incident. And there's some military things that fall under that as well. So if you have over 50 employees or learning more about FMLA is something that you need to do, lots of really great resources out there. And I'd be happy to point you in that direction. And then with the Affordable Care Act, the folks that have over 50 employees or more, or organizations that have over 50 employees, have to provide healthcare as well, affordable coverage. And there are some additional requirements with the healthcare and the ADA as well. So happy to point you in the direction of any resources related to that, if that is something that you're interested in. So we'll talk about a few more things here. Discipline and documentation, so not fun, right? And as an organization, as leaders, it's really important to have some pretty specific processes, procedures, and things that you're following in relation to discipline and documentation. So first thing is you want to have a written policy. You want to have a written policy that you can refer back to and follow if you have to proceed with any discipline in the workplace, as well as documentation. Something that's important is you want your written policy to be flexible enough to be able to move through the steps in that policy. So a discipline policy, right, that you often see in the workplace is somebody gets a verbal warning, written warning, second written warning, final warning, termination, right? Or maybe they have to take leave from work and then they're terminated, whatever the situation is. You want to have your policy flexible enough where you can move through to different steps based on the nature of the situation. So if the behavior or the situation that happened in the workplace is severe enough, you might want to jump right to that final warning, or you might even jump right to that termination. And you want to make sure that your policy says something like, may move through different steps of this depending on the nature of the incident. One really great resource is SHRM. Again, I mentioned SHRM, the Society for Human Resource Management. They have policy templates on their website about pretty much any policy you could ever want, including a discipline documentation policy. And then speaking of documentation, you want to document every step. So you probably heard this said before. If it's not documented, it didn't happen. So document everything, especially when it comes to disciplinary action at work. You want to document the specifics of the violation, as well as any expected behavior changes and potential consequences, right? And you want to be consistent. And formal discipline does go, or should go, in an employee file. So we talked about employee files before. So you want to make sure that when you are documenting the scenario, right, the specifics, behavior changes that are expected, et cetera, that you're really being objective and factual when you're documenting everything. And then termination, right? Hopefully you don't get to termination. But if you do, there are just some things to think about. So technically, Wisconsin is an at-will state, or an employment at-will state. What does that mean? That means that employees or employers can terminate without giving prior notice, right? So the alternative to employment at will is when there's a contract in place. We don't have that as a requirement for employment in Wisconsin. So if somebody decides to leave, it's typically best practice to give 2-week notice, but they're not on contract to stay employed with you until December. And same for you. If you need to let somebody go because of performance or downsizing or whatever the case may be, that's something that you can do. You still can't do anything illegal when you're terminating people. So even though Wisconsin is an at-will state, the termination reason cannot be for discriminatory reasons. It cannot have any harassment involved or anything like that. So even though technically we're an employment at-will state, we still have to follow all of the employment laws that the EEOC has in place for treatment in the workplace. You want to make sure that you are maintaining confidentiality and privacy when you're going through the termination process. Having termination discussions is challenging. So a best practice is to recap issues and not rehash issues. So you might be sharing with the individual why they're being terminated. We're not here to rehash it. The decision has already been made. We're going to recap why, and then talk about next steps, which is another best practice. So talk about final paycheck, benefits, etc. There are some at-will policies that also on the SHRM website, and you could probably find them in a variety of places online. Really important to have an at-will policy. Oftentimes you'll see this in job applications as well as in employee handbooks, just reminding people what that means. So we only have a few minutes left, so gave you a few resources today. Happy to recap those resources and share them with everybody after this. For small businesses specifically, the Small Business Administration has a lot of resources when we're talking about employment law. So check out the Small Business Administration website. And then lastly, a small plug. So again, we went very high level today. I do facilitate a full day HR basics course through the UW Small Business Development Center. So I'll be doing that this fall on October 29th. It's all day, 8:30 to 4:30, and there's an option for in-person as well as virtual. So we will cover the things we covered today, in addition to a lot more. We didn't talk about job descriptions. We didn't talk about FMLA, OSHA, background checks, different things that we'll spend a bit more time on. So if that's something you're interested, you can let me know as well. And that being said, I will turn it back over to Pete for questions.
Awesome. Thank you so much, Brittany. That was a lot. A lot.
Yeah.
So as we're thinking about all of the things you have been chatting with us on, I'm thinking of our nonprofits or small businesses. Somebody's wondering if we're just starting to like formalize our HR or clean up what we have not really concentrated on. Can you like recommend what are the top 3, 4 things we should be working on as a starting point?
Yeah, that's a great question. So I would say getting everything in order to be ready to, hire people appropriately. So we didn't talk about job descriptions today. Job descriptions are really important for a variety of different reasons. So have a job description, even if you're just hiring one person, or maybe even a job description for yourself. If you are hiring somebody, being familiar with those regulations in regards to pay. So we talked about those mandated benefits like Social Security, Medicare, being familiar with that. Those are the top two that I'd say come to mind for me for an organization that is getting started out, to be ready to have somebody on staff. And I guess I'll add to have policies written. So again, even if you're just going to have one person, you want to have those policies to fall back on to make sure that you're creating the work environment you want to create, and you have some protection as an employer. If anything does go awry, you can refer back to the policies that you have in place.
Awesome, thank you. Stephanie is wondering, does our employee manual slash handbook need to be vetted and approved by legal?
Good question. Technically, no. Technically, it doesn't have to. Technically, you don't have to have employee handbook. So they're a best practice and you want to, but there's no laws in place that say you have to have an employee handbook. So if it's a best practice to have it reviewed by legal. I'll say especially because August of last year, I believe it was August of last year, the National Labor Relations Board updated some regulations in regards to how policies can be worded in the workplace. And we didn't talk about the NLRB today. I talk about that in my class, but that's something, another example of why if you have that resource and the ability to have a legal professional look through it, it's recommended to make sure that your policies aren't, for example, inadvertently discouraging people from, gathering and talking about their work, which the National Labor Relations Act protects people in the workplace and their ability to gather and talk about their workplace and potentially unionize.
Okay. You touched on something there. If I'm a small nonprofit or a small organization and I maybe contract out with somebody for my HR, how often do you recommend I touch base with them? Where do you recommend I go to stay on top of things like the changing legal challenges to certain laws that may apply to me?
Yeah, great question. So um, there's a lot of, so I would, recommend keeping in regular touch with any individual you're contracting HR out to, whatever makes sense for you, depending on what you're doing and what, type of organization you have. I think weekly, maybe bi-weekly, I'd say at least monthly. I probably wouldn't recommend any less than that. And I mentioned SHRM. SHRM is an excellent resource. Membership to become a national SHRM member is maybe $300 a month. So it's not free, unfortunately. And I know nonprofit, small businesses, budgets are really important. However, that membership gets you access to loads of templates for policies, procedures, employment law updates. You can talk to professionals through SHRM. So that's a good resource as well if someone is in, or a good resource to keep up to date on things that are changing. There's some great local organizations as well that send out different, I'd be happy to share these, but that send out newsletters to keep you updated as an employer on changing laws too.
Okay, excellent. Thank you. And I see that we are up against time. Do want to be respectful of everybody's time, especially as we're moving into lunch hour. So if you have a question that is sitting in the queue and has not been answered, we will work to get back to you to clarify or give you some sort of response. And apart from that, Brittany, thank you so much for sharing your time, your expertise with all of us. And I thank all of our participants for tuning in and hearing what Brittany had to share. We look forward to seeing you the next time we have our webinar, and I hope you have a great afternoon. Thanks, everyone.